Mediation is a process in which a neutral third party, known as the mediator, works with disputing parties to help them explore possible ways to resolve their issues. The mediator's role is to help facilitate settlement discussions between the parties. But the mediator is not a judge, and he or she does not get to make the decision about how to resolve the case. In family law cases, mediation can be a useful process to help the parties resolve their divorce-related disputes. In fact, in North Carolina, if a party files an equitable distribution claim with the court, mediation of that claim is mandatory. However, the parties can also voluntarily agree to discuss issues related to child support, child custody, and spousal support. One of the benefits to mediation is that it is often quicker and more cost-effective than going to court. The parties have more control over how quickly they will attend mediation and how much time and money they will devote to the process. In addition, mediation gives parties the ability to agree upon a solution that is more tailored to their particular family. Parties who mediate their disputes rather than allowing a judge to decide for them are able to address the fine details of the agreement, such as a more nuanced custody schedule or a creative property settlement. Mediated settlement agreements can include specific procedures for how the terms of the agreement will be performed. Because the parties were involved in creating the agreement, there is often a higher likelihood that the parties will actually comply with the terms of the settlement. With all of its benefits, mediation is not right for every case. Unlike a courtroom setting, mediation typically has very few rules. This lack of formality can be great for promoting settlement, but in cases where one party is timid and the other party is more vocal and aggressive, the timid party runs the risk of not getting everything to which he might be legally entitled because he is unable to assert his position. Having a lawyer present during the mediation to represent your interests can help mitigate this problem. But in some cases, particularly those where domestic violence is involved, mediation may not be appropriate. In such cases, mediation may just perpetuate the power imbalance and provide another way for the abuser to harm the victim if the victim is not comfortable asserting his or her position. Finally, there is no guarantee that mediation will be successful and the parties will reach an agreement. If mediation is not successful, the parties may have to go through the time-consuming and expensive process of trial after already having spent time and money to prepare for and participate in mediation. While mediation might not be the best course of action in every case, because of its potential benefits, mediation is an option that should at least be considered. If you have questions about whether mediation would be appropriate for your case, you should consult with a family law attorney.